Hey everybody, how's it going? Welcome back to Copper Jacket TV. So unfortunately, we've got some bad breaking news today. The Supreme Court just issued a 7-2 decision against our Second Amendment rights and for the ATF. So let's talk about what happened. Now, if you're watching this video and you have not yet subscribed, consider hitting that subscribe button. It's free, it only takes a second, but it really helps us out here quite a bit, and it helps us spread our pro-Second Amendment message. A thumbs up is always appreciated, and that little alarm bell, click that, and that'll let you know when new videos come out. So, with that being said, let's get to it. Okay, so let's go ahead and talk about what just happened here. So the Supreme Court just released its decision in a case now called Bondi v. Vanderstok. This is a case that challenges the ATF's final rule on frames and receivers. Now, like I said before, we lost this case. This was a complete blowout, a 7-2 decision. The majority opinion was written by Justice Gorsuch, and of course you can guess who the two dissenting judges were. They were Justice Thomas and Justice Alito. Now, obviously, this opinion is going to have major consequences for those people who like to build from these kits, but it's also going to have major consequences for those companies who manufacture these kits. Now, the issue at hand here that was presented to the Supreme Court isn't necessarily about the constitutionality of being able to build something on your own. The question that was presented to the court is whether the final rule violated the APA and whether the final rule falls within the statute of the GCA from 1968. So basically that was what was presented to the court. And so the court had to look at this from the lens of, does it fall within the statute? And the court basically said that yes, it does. Now, I, like most of you, I'm sure, agree with Thomas and Alito in their dissent, where they basically say that this gives the ATF way too much power to regulate inanimate objects, and that this does not necessarily fall within the GCA because it's way too expansive. But let me go ahead and show you guys some actual documents here from today's opinion to kind of highlight what happened. Okay, so here you can see Supreme Court of the United States in Bondi v. Vanderstok, and this is on writ of certiorari from the Fifth Circuit Court of Appeals. It says, Justice Gorsuch delivered the opinion of the court. For decades, the Gun Control Act has regulated the sale of firearms. This case poses the question whether the Act's long-standing mandates also apply to those who make and sell a new product, quote-unquote, weapons parts kits. So Gorsuch writes, as presented to us, this case does not ask us to resolve whether ATF's new regulations 478.11 and 478.12 may be lawfully applied to particular weapons parts kits or unfinished frames or receivers. Instead, the plaintiffs have pursued what the lower courts called a facial pre-enforcement challenge to the agency's authority to regulate any weapons parts kits or unfinished frames or receivers. In a challenge like that, the government represents the possibility that ATF's regulation may be invalid as applied in some cases, does not mean that the regulation is facially invalid. Instead, the plaintiff's burden is to show that the rule itself is inconsistent with the statute on its face. Now, he continues later on in the opinion to say, while we recognize the problem, this case does not require us to untangle exactly how far subsection A reaches. The plaintiffs argue only that 478.11's provisions addressing weapons parts kits is facially inconsistent with the statute. The Fifth Circuit adopted the same view after coming to the unqualified conclusion that weapons parts kits can never satisfy the statute's two tests. To resolve this case, it is enough to say those assessments are mistaken because at least some weapons parts kits satisfy both of subsection A's tests, 478.11, is not facially invalid. Future cases may present other and more difficult questions about ATF's regulations, but we take cases as they come and today resolve only the question that is posed to us. Now, even further on down in the opinion, Gorsuch actually says what the final nail in the coffin was for the plaintiffs in this case, and the plaintiffs are pretty much us. So he writes, last but not least, the plaintiffs represent that they have no quarrel with the ATF's prior practice. In its concession, that all but gives the game away. Of course, the plaintiffs think the agency's new rule reaches further than the statute can bear by seeking to regulate some products too far removed from finished frames or receivers. But for our purposes, what matters is that even the plaintiffs did not really insist that subsection B reaches only finished frames and receivers. So that last paragraph that we read right there was basically where Gorsuch was saying that the plaintiffs kind of stepped in it on their own. So the issue that I see here, other than the fact that I feel like the Supreme Court definitely got this wrong, but I also feel like this is going to lead to even more confusion. What is considered a parts kit? What is legal under the statute and what is not? What is up for interpretation and what is not? This is going to lead to more confusion, more lawsuits. There's going to be a lot that's going to happen because of this. Now, I was able to read the entire opinion before I jumped on here. Some of the stuff I just kind of skimmed through when it came to the history of the case and stuff like that. But when it came to the meat and potatoes, I made sure to read the meat and potatoes of this case. And I can tell you, it's going to lead to a lot more lawsuits. It's going to lead to a lot more confusion amongst the courts. And you're going to see a lot happen from this. I think a lot of people are not going to know what product and where they stand with that product. So there's going to be a lot. It's a terrible decision. Absolutely terrible. But that's what the Supreme Court did to us in this one. And it really kind of makes me lose faith in the Supreme Court as well. Because obviously the ATF is just overstepping its boundaries here. The way that I see it is, even under the GCA, they're overstepping their boundaries. And the GCA itself is unconstitutional. So supporting a law that falls within the GCA on its face is unconstitutional. You can't have one unconstitutional law be upheld simply because it falls within another unconstitutional law. That's just not the way that things should work. So the Supreme Court should have said, look, the GCA got it wrong. The GCA is unconstitutional, and therefore this regulation is unconstitutional as well, or something to that effect. I'm sure you guys follow where I'm going here. Anyway, I wanted to let you know about that. I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe if you haven't already, and you guys have a good one.